The next case to come for video oral argument is Durham Ridge Investments LLC versus Lorain County Board of Revision et al. Each party will have 15 minutes to present your argument if you are the appellant, and you may reserve up to 5 minutes for rebuttal. Please just let me know before you start your argument. I'll do the best I can to track the time for you. These arguments are being visually and audibly recorded. They are on a live feed as we speak. Please don't use the names of any minors or victims, although I don't believe that is applicable in your particular cases. We have read your brief. We are ready to proceed when you are. Mr.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay.
And may it please the court, my name is Stephen Hanadel. I represent the appellant Durham Ridge Investments LLC. This pertains to the tax valuation of a collection of parcels that comprises of Greyhawk golf course in LaGrange. And this goes back a long ways, actually, back to 2010, in which, in early 2011, my client sought a downward valuation from the Board of Revision. He presented a full appraisal report to the Board of Revision, but however, they failed to make that part of the record. And when we took this matter to the trial court in late 2011, we asked the trial court to supplement the record with the full appraisal, which that has been proffered into the record, the 116-page report. And the transcript of the Board of Revision hearing does show that he did bring one copy of the full appraisal report and submitted it to the Board of Revision, and pages 2 and 3 of the transcript bear that out. And that's important because it seems that the trial court's decision and the appellee's arguments are premised upon the notion that he did not present the appraisal report, and therefore they're trying to direct this case into a different set of law to apply, when in reality he did present the appraisal report, and therefore that should have been considered, and that would trigger another set of law. And I want to direct this court's attention to its own case from 3 years ago, is O.M. Heracrucian versus the Summit County, I believe it was Summit County Board of Revision. It's a case out of Summit County where there was an issue about the appraisal, and which this court had held that, first of all, that the appraisal was done for the purposes of the mortgage. It was done for the bank, but just because that's the case, that doesn't render it incompetent for tax purposes, because ultimately the court has to look at the appraisal's thoroughness and in-depthness as well. And in this case, 116-page report really combed through all the different aspects. I mean, valuing a golf course is not like valuing someone's home or any other typical commercial property. It's a very, very unique in of itself, and that requires a very specialized analysis, which is what my client had obtained. And the date of that appraisal was April of 2010. He was asking for that to apply to January 1st, 2010 tax year. And the appellees have raised the point that, oh, well, April 2010 is not January 2010, but it's close. It's 3 months. It's within 3 months. And in fact, when my client actually had to order that appraisal he ordered that appraisal in December of 2009, and it just took time for that appraisal to be done, because again, valuing a golf course is no simple, easy process. And so there's case law, especially in the O.M. Heracrucian case, and as well, and I have other cases cited in my brief where the approximate time frame is what matters in a case-by-case basis. And the fact that the appraisal is within 3 months of the tax date, I mean, that's closer than what other cases have found to be competent and credible and sufficient. Because there are cases that where the time gap is longer, and the courts have found that to be okay. But most importantly, again, just getting to the factual issue, because I think once the factual issue is recognized, then the law kind of takes care of itself in terms of just the domino effect, because on page 2 of the transcript, my client said, I have the full appraisal here. I just didn't feel like copying 116 pages. I have the full appraisal that can be submitted. And there's some questions about the appraisal, who was it done for and why. But then on page 3, at the very end of the hearing, the question was asked to him, are you able to submit the full report? Do we want it? And my client said, it's right there. They asked him, is that our copy? He said, it's yours. And they asked him again, is that our copy? He again said, yes, that's yours. And that's when they took the matter under advisement. There was no specific objection made by the school board when my client was there over the appraisal report. I think that's important. And also, the appraisal very more than sufficiently rebuts the auditor's value. And I believe this court held in the Heracrucian case as well 3 years ago, that when the auditor or the school district do not offer evidentiary support for the auditor's value, after the property owner presented appraisal that affirmatively negates the auditor's value, when the auditor and school board don't present anything in return that can in any way support the auditor's value, the trial court cannot just simply revert to the auditor's valuation. And that's exactly what the trial court did here. The trial court incorrectly found that my client did not present the appraisal report, and by the way, never held a hearing. And I think at the very bare minimum, if the trial court had reservations about ruling for my client, should have at the bare minimum held a fact-finding hearing. I mean, which the trial court was well within its rights to do. The Board of Tax Appeals does it all the time in other cases. And in fact, I think one case cited by the appellees, which I believe was the Plain Local School District Board of Education versus Franklin County Board of Revision, then went to the Supreme Court. And in that case, the Board of Tax Appeals held a hearing in regards to the time frame of the appraisal report. And in here, the trial court held no hearing at all. It just went ahead and just adopted the appellee's characterization of the facts, and the record just simply does not support that characterization. And the record very much supports that my client brought the full appraisal report to the Board of Revision hearing, and he submitted it. And it's not his fault that the Board of Revision did not fulfill its duty to preserve the record. And we sought to correct that and remedy that by motioning to supplement the record at the trial court. But unfortunately, the trial court denied it, and the trial court also didn't want to hold a hearing either. And at the very bare minimum, if there's any question as to whether he presented the appraisal or not, a hearing should have been held. And because the transcript has more than enough minimal support to show that he presented the transcript. And if the trial court had any questions, it should have held a hearing instead of just adopting the notion that no transcript was submitted at all, in which the record just simply does not support that. Because once it's found that
remind me, what was the basis for the denial of the motion to supplement the record? Was it that the court concluded that it was not submitted, the report was not submitted at the board?
I do not specifically recall. My recollection is that I don't think the trial court provided a reason. And again, I'm just going based on my rough recollection here, because that was separately denied before the court issued a final decision denying the administrative appeal altogether. So, but once he denied the motion to supplement, I mean, that put us in a very tough position overall, because yes, we need that appraisal report in the record and to be duly considered for my client to succeed on this claim. But the thing is, he did what he was supposed to do. He brought the appraisal report to the hearing. He submitted it. The transcript of the Board of Revision hearing reflects that. And again, if the trial court had any questions as to whether he really did or didn't, and especially when the opposing side disputed that fact, that's what the trial court's there for, to resolve factual disputes. The trial court's not supposed to just take one side without having a hearing and adopting evidence unless the record is fully clear. But when both sides are disputing what the facts are, that's where the trial court should step in and say, okay, let's hold a hearing, let's sort this out. And it didn't. It just adopted the adopted the appellee's side of the facts, and which I don't think is accurate based on the record and the transcript. And I think once it's found that the transcript was submitted, then everything else falls into place. All the case law favors my client at that point, that the trial court had no basis to revert to the auditor's value when there was no support provided to, for that. And we're talking major difference. We're talking from what 4.6 million to 1.8 million in valuation. It's a lot of money, and especially this is back in 2010. This was just coming off the heels of the Great Recession. When property values overall steeply declined, and so my client he submitted an appraisal to reflect that change in the market. And in the appraisal, again, 116 pages, it provided two separate theories of valuation. And my client actually submitted the higher one just to give the benefit of the doubt to the auditor. And and yes, just because the appraisal was done for the purpose of the bank does not automatically mean that it's incompetent for tax purposes. In fact, it's very competent for tax purposes.
Hang on one second. Hang on. Counsel, I just want to let you know you're into your rebuttal time. You can continue. It's up to you.
I'll answer Judge Teodosio's question.
All right.
Quick, was it necessary for that appraiser to appear before the board and in order to authenticate the report and avoid a hearsay issue?
It was not necessary because it was an administrative hearing. The rules of evidence do not apply to administrative hearings. That doesn't mean that the evidence cannot be unreliable. I mean, there's certainly a reliability factor, but no, the appraiser did not have to be there. My client.
I understand. I understand that argument. I don't want you to take up more of your time. I understand on that. Thank you.
Okay, thank you. I'll say the rest for rebuttal.
All right. Ms. Finnegan, whenever you're ready.
Thank you, and may it please the court, my name is Kara Finnegan, and I am representing the appellees, Lorain County Auditor and the Lorain County Board of Revision, although as indicated at the beginning, I'm also arguing at this point for the Board of Education here, just because our positions are so similar in this regard. Initially, I think I just want to kind of go over some of the things that I didn't really agree with in Mr. Hannadel's argument. And the first thing I kind of want to clarify is whether or not that appraisal actually was a part of the statutory transcript and whether that was submitted as evidence. As this was 10 years ago, it was long before I was with the office and certainly wasn't present at any of these hearings. However, according to the transcript, it does look very. It's hard for me to get from this whether or not that was actually intended to be submitted as evidence. I do see that it was a very lengthy report, and the property owner didn't wish to copy that for everyone. However, generally, when we're talking about evidence, even before the Board of Revision, even though we don't necessarily strictly follow those rules of evidence, we do try to maintain some sort of order to those hearings, and generally we would assume that you would bring a copy to submit as evidence to the board, as well as bringing a copy for other parties such as the Board of Education. It doesn't appear that that's what happened here. Obviously there was enough confusion that there was only a couple pages of the appraisal report that were focused in on at the hearing, and at the end it kind of appears that the board is asking the property owner, do you want us to have this? Is this? And it's just kind of like, but yeah, it's your copy. You can have it. It doesn't, there's nothing here saying that that is the part of the evidence that was considered. And as Judge Teodosio asked, in regards to having an appraiser there who had authored the report, that was also missing. I would point out that this was actually not the property owner's first go around with the Board of Revision. This property had actually gone before the BTA in 2008, where the value, I believe, was much closer to the initial auditor's value for this property, which for January 1st of 2010 was $4,658,600. The property owner at that point was requesting a reduction to $1,880,000. So quite a significant reduction there for a 2-year period. Additionally, so since he had been through this process, had gone to the BTA, I think that the property owner here, even though he represented himself, should have been aware of some of these concerns that the board would have had, such as the appraiser not authoring the report, the fact that the appraisal was not done for purposes of tax valuation or ad valorem tax valuation, that it was done for purposes of a mortgage essentially, and the case law has demonstrated, as I've pointed out in my brief, that those are often have different considerations that go to them. The appraisal problem is generally framed differently, and so that will generally affect what work product you have when you're looking for an appraisal that's been done for mortgage purposes as opposed to one done for ad valorem tax purposes. So that's something, again, that adds to kind of to what extent is this appraisal report competent or incompetent. And I guess I would agree with Mr. Hannadel that necessarily it's the only problem here that is that it's and I know he said 3 months. I believe the actual appraisal date was April 28th of 2010. So we're getting more into the territory of 5 months from the tax lien date. But if that was the only issue with the appraisal report, I think that generally there would be, maybe that's not the only thing, that is of issue there. But then we also have the fact that the author of the appraisal report was not present generally before the BTA. This would render the appraisal report hearsay. It's harder for board members at that point, or if this would go before the judge, it would go before the Board of Tax Appeals, that it's harder then to know why an appraiser is making certain adjustments, why he viewed things a certain way, and how that impacted the value conclusion at the end of the day. That was not presented here before the BOR. So that appraisal report gets a little more incompetent as we go, with all of these things adding up. And additionally, I said we're looking more at 5 months from the tax lien date, and we've got a different purpose for the appraisal. We have no, appraiser there. So this is not something that necessarily looks like competent evidence before the Board of Revision, so they retain the auditor's value. My understanding then is when it gets to the Court of Common Pleas that the property owner does make that motion to supplement the record with the appraisal. But it's my understanding that the court didn't just take one side over the other. Coming in as somebody who did not handle anything at the level below, I did not read anything in this case to be that way. It looks to me that the court had the motion before it, asked for briefs to be written and submitted by the parties. That was done. Those briefs were read and considered, and a decision regarding whether or not to supplement the record was issued by the court. Following that, briefs were submitted generally on the matter, and the court issued a decision from which the property owner appealed. So, the standard here is not if there was a dispute as to what the actual facts at the below hearing were, that the court must hold an evidentiary hearing. The court may supplement the record. The court has the discretion to hold those hearings, but it doesn't have to do that. It's looking for a review de novo, not necessarily a trial de novo. So it seems to me that the court did not here act unreasonably or arbitrarily. It looks to me as though the court entertained briefs on the matter and did consider the arguments of all parties here involved, and following those briefs came to the decision it did. And regardless of whether it did, it's not necessarily here whether there was an error in judgment or an error in law. It's, was this unreasonable? Was this arbitrary? It doesn't appear to me that it was, from the court's steps here to address the issues that have been presented here regarding, should this appraisal report have properly been before the Board of Revision? I don't want to comment on too much exactly what happened at the Board of Revision hearing. I know we do have a transcript before us, but I wasn't a part of that, and the problem here, I think, is that nobody was a part of that.
Well,
But based on the
counsel,
Yes.
In that regard, in terms of the trial court's finding that it says that the appellant only offered a few pages of the 116-page report. So I'm left with the impression that those pages are in the record. Is there something in the transcript that indicates that there were just multiple copies of a couple of pages that were proffered? And the trial court knows it's a 116-page report, maybe because of the motion to supplement, but is it your reading of the trial court's order that there are a few pages of that appraisal in the record? And it's just that the whole appraisal is not in the record, or?
My understanding, and I don't know that even a couple of pages of the report are in the record. I think though there were questions about it, at the end of the day, I may be incorrect, but my recollection is that there is nothing regarding the appraisal report in the record, and I think that is because it does appear at the end of this transcript of this hearing before the board that it's not clear to me that the property owner is asking this to be submitted as an exhibit. Generally our board will ask, do you want to submit this as an exhibit? Something to that effect, or somebody will submit it, and say we would like to submit this as an exhibit. Generally, we will ask for, and that's, I can talk to, what the procedure is now, is we will ask people to submit any evidence they wish to present to the Board of Revision 14 days in advance, and to provide those copies of anything you wish to present as evidence to any other parties, such as the Board of Education, something to that nature. And that doesn't appear to be what happened here. It appears that it just he brought this report along with him, kind of handed over a couple of pages of the report. And this is from my reading of the transcript. And that, at the end of the day, he was like, well, I didn't want to make, copies of the whole thing. And I can understand this is a lengthy document, but this is something the Board of Revision deals with, every day when they're considering these matters. Additionally, like I said, I do believe that the property owner had been through this process before. So I know he was representing himself, but still, has to bring that evidence. He's still expected to, independently show, or not independently, I'm sorry, that's not a correct word for me. He still has the burden to prove that lower value of the property. And it doesn't appear that happened at the Board of Revision. And it doesn't appear that even if that appraisal report had been submitted below, that it would have been competent evidence, because again, we're looking at 5 months past the tax lien date. We're looking at no appraiser to authenticate the report or to speak to any of the adjustments made. So I don't even, the appellees would argue that even if this report were properly included, it's not competent evidence to prove that lower value. And that gets to kind of another big point I want to make, is that Mr. Hanadel has indicated that the auditor's office did not put forth any evidence of the auditor's value, and neither did the Board of Education. However, I would indicate that is not the auditor's burden. It's not the Board of Education's burden. Once the property owner or the complainant has established that a lower value or a different value should be set for the property, then the auditor and the Board of Education, or whoever other the appellees are, then it's their burden to come back and show why a higher value or the auditor's value is the best value for that property. But that's not what happened here. The initial burden was never met, to show that a lower value, this value of $1,880,000, was appropriate for the property. So at that point, there's no requirement that the auditor come in, or the auditor's counsel come in, the Board of Revision's counsel come in and improve that value. The initial burden is on the property owner, and that never was met here. And I would say that as I just pointed out, even if the appraisal had been, at the trial court, at the board, admitted, it still has some fatal flaws that are hard for the property owner to overcome, like I said. And so I don't believe that the case law favors the appellant, should that appraisal report had been submitted, whether or not, they intended for it to be submitted as evidence or not. And I do believe it's on the property owner or the complainant at that point to make it clear, I want this considered as evidence. I want this entered into the record. The transcript here feels very, if you want it, go ahead and look at it, which is not sometimes unusual, that people will come and say, well, you can take a look at this, but not necessarily, use that as evidence. They might just say, yeah, sure, if you want that, or we don't need it if you want to keep a copy, but that's not always the same as we want that as evidence. And I see from the transcript here down below that it does look as though there was no mention of, is this document evidence you want considered by the board? It's certainly discussed.
Counsel, at least when we get to the trial court level, we have an order that says this was not proffered, but here's why this evidence that is not in the record is not competent, credible evidence. So are you kind of left with examining the merits of the evidence that's not in the that has been said is not in the record?
I don't know if I quite understand what you're asking me. Are you saying because it's not in the record, why are we considering it?
Well, I just posed the question: what impact does the fact that the court went on to talk about whether this was credible evidence, whether it had any value, after it had already determined that this was not evidence in the record? What's the impact of that?
What's the impact of that? I don't know I don't know if I can really say what the impact of that is, other than to say, for purposes of appeal, I think that, this kind of is, it's not plain error, in my opinion, that this is, this has not been, it's kind of the standard we're looking at here is, was it arbitrary and unreasonable? And I don't know that just because the court here took a look at what impact the appraisal would have had it been, if there was no question, this was supposed to be submitted as evidence. I don't know that. I think the court is looking at, is this something that will make a difference in the long run? And certainly in reading the briefs, I know that those points were made by the parties, talking about, that there was no appraiser, there was talk that it was for the wrong, it was done for mortgage purposes. That's, that comes out in the Board of Revision transcript as well. So I think that these arguments have all been presented by the parties, and the court is addressing those things.
Counsel,
yes.
Excuse me, your time is up. If you want to do a summation sentence, go right ahead and wrap up.
Sure. So I would just indicate that here what we're looking at is that the property owner had the burden to prove a lower value and did not do that here, and it's not on the auditor to prove the value it had. Additionally, when it gets to the Common Pleas Court, the Common Pleas Court is not taking a side. It looks like it considered briefs of all parties, arguments of all parties, and based on those arguments, came to a conclusion that it was going to uphold the auditor's value. And I don't believe that is for any reason unreasonable, arbitrary, or unconscionable. And I would ask the court to uphold the Common Pleas judgment. Thank you.
All right, thank you. Mr. Hannendel.
Thank you, Your Honor. To address the point as far as what Judge Hensel had raised the question, whether just a few pages of the transcript already in the record. To my recollection, the answer is no. Now, going back to 2011, when I first took a look at the record at that time, when I just filed the appeal to the Common Pleas Court, and I looked at the record, and I had to go to the Board of Revision to get the full transcript and do a precipice to have them send the full transcript to the trial court, and then they gave me a copy, and then I looked at what was in the court file as well, and my recollection, there was no appraisal at all. Not only just a full appraisal, but not even a couple pages from it, and that's what triggered my alarm, is the thinking, okay, something's wrong here. And so, and that's what led me to file the motion to supplement. and especially with the transcript handy, that showed that my client did submit the full report, because from the very beginning, my client has been very adamant. He said, I gave him the full report. I gave him the full report. And really at this point, that's what he wants to have reflected as far part of the findings in the record. Because again, once that's found, I believe the law takes care of the rest. And as far as the Board of Revision's duty, it's under revised code sections 571508 and 571505. Both require the Board of Revision to preserve the appraisal report as evidence and certify it as part of the record. And that's under Vandalia Butler City Schools versus Montgomery County Board of Revision in the Ohio Supreme Court in 2011. And also, during the hearing part of during the question and answer phase of the hearing before the Board of Revision, the school board did not object to the appraisal report. Now, at the very end, after questions and answers have been done, and because the board said they're going to take the matter under advisement, but then there's a separate part at the very last part of page 3 where it seemed like they called the case again, and this is, presumably with my client not present or nobody else present, just the board. That's when they said that the school board objected based on hearsay and the evidence being presented by a non-attorney. But in the question and answer part of it, there's no indication that that's the case. And so I believe that in the Heracrucian case that that there is a distinction. This court had found in the Heracrucian case that that the fact that the school board did not object specifically on hearsay or anything else during the question and answer phase, that there's no objection. So I think that's important as well. And ultimately, our argument does rest upon the fact that the trial court abused its discretion. Yes, we know the trial court did not have to hold a hearing. It was not required to. But in this particular case, based on the facts and circumstances in the record, it should have held a hearing, because the record simply does not support the notion that the full appraisal report was not presented to the Board of Revision. In fact, the record very much supports my client's contention that he provided the full appraisal report. And that's all I have. And we would ask that the court reverse the trial court's judgment and remand it for further proceedings.
All right. Thank you both very much for your arguments. We'll take the matter under advisement. We'll issue a written decision in due course. It will be mailed to all sides, as well as posted on our website and on the website of the Supreme Court of Ohio. We will next have video or